Good morning. Thanks for attending the Patent Troll panel. My name is Alan Schoenbaum. I'm the general counsel at Rackspace hosting in San Antonio, Texas, and I'm a patent troll radical and notorious blogger and trying very hard to influence Washington and the patent troll to change the game and get some legislation that will help solve this problem that's affected many of our companies. I want to introduce the panel. I'll go from the far end. Julie Samuels, who is an attorney at the EFF, who is an inspiration to me on intellectual property issues and patent troll. Julie is a lawyer who has been a trial lawyer. She was at Loeb & Loeb and Sunshine in Chicago, went to law school in the South, so she has a little bit of flavor for the South, and she loves Austin, Texas. So Julie has served on many panels on patent trolls, and the EFF has actually done probably as much as anyone to highlight the issue and help solve the problem. And to her right is Russ Reeder, who is the president and COO of Media Temple, which is a large web hosting cloud services company. And Russ is going to give us some notion of what it's like to be on the operations side of a patent troll problem. To his right is Jeff Hunsaker, who is the Chief Services Officer for UK2 Group, which is a UK company with US operations and he has to explain to them what it's like to be in the United States under our system of laws, which is very different than theirs, because they don't have this problem in the UK, not like we do. And then to my immediate left is Professor John Golden, who is a professor of law at the University of Texas at Austin, my alma mater. And he is a Harvard-trained lawyer and has a PhD in physics and served as a clerk on the United States Supreme Court, that's about as good as you can get. So we've got a great panel, and I want to thank all of them for participating. So we're going to start off with a short PowerPoint, which I borrowed from James Besson. Does everyone know who James Besson is? James Besson wrote the best report, study, or co-authored it on the economic impact of patent trolls. It's known as the Boston University study. He's a friend of Julie's and is just really extremely well regarded in the industry. So we have a short presentation just to kind of introduce the subject matter. 5 facts about patent trolls. There's a little information about Professor Besson. So the study is called The Direct Cost from NPE Disputes. NPE is a nice way of saying patent troll. So first, it costs a lot of money to defend a patent infringement case. Who all here has been sued by a patent troll? Anyone? So you know, those of you who haven't, it's very expensive. Most people settle. It's like a game of prisoner's dilemma. The patent troll game is they want to get you to settle out quickly so they don't have to spend a lot of time on it, and they generally will settle for far less than it would cost you to defend. So your lawyers will tell you, hey, just settle. It'll be a whole lot cheaper than paying me to defend you. People do it. Here's the cost to the economy. So the total direct cost of legal costs and settlement of patent assertion entities, $29 billion. And for small, medium-sized firms, $11 billion, which is really, look at the way it's escalated up from early in the game, 05 to the present. It's just gotten worse and worse. The problem is getting worse. They hit small firms. 82% of the defendant firms are less than $100 million in revenue. Median revenue of $10 million. So it's not just the cases against Microsoft and Cisco and Google. It's small companies like yours. And here's a distribution of the targets. tech firms, 29% computer software, electronic communications. So it's 70 to 90% of the patents are software business method patents, which are the most difficult patents to understand, because they're generally, we can talk more about this later, the way they're written, they're so poorly and broadly. And these are older patents as well. One of the big arguments patent trolls will make is this is good for the economy because it allows inventors a way to monetize their inventions. That's just a bunch of bull. They get, as you'll see, the inventors generally get only 3% of the money that comes out of these patent troll cases. 3%, very small amount of money. A lot of them just get nothing because they're developers that work at large companies or small companies, and they're doing their jobs. They write the code. The lawyer comes in, figures out how to write a patent around it, and that person gets nothing more than his or her salary. So it's not. So the big argument is just full of holes. And the fifth point is that it really acts as a tax on research and development. If you'll see, the money spent on patent trolls is just under what actually is spent in R&D. So with that background, I want to ask the panel about their view on why the system isn't working and maybe get them to tell some stories. So, chief storyteller to begin with, I'll start with Russ.
Chief storyteller, all right, great. So I've written patents. I have a couple patents issued. I've licensed patents, and I've been sued more times than I like to admit. So I actually ran a company in Austin. That was a digital publishing company, and we were not sued directly by patent trolls, but in the software business, you usually indemnify your customer. So our customers were Random House, HarperCollins, Simon & Schuster, Macmillan, multi-billion-dollar companies were using our application. So when you go and read a book online, you actually can, that technology from Adobe has been around for a long time in the software world to be able to read books online. And so a patent troll had gone and sued and settled already with Google. And then they came to sue all the publishers, right? Here are the big fish. They've already settled with Google. And it comes down to the small software company in Austin, Texas. And so here we are. Not only does this company, Libre Digital, have prior art that we have to prove it. We have to have documentation to make sure we can prove it. Adobe has prior art. And so we're like, all right, game on. Let's go. We've got prior art. We're gonna fight this thing. We sold the Libre Digital when we were $500,000 into the battle, right? And so you have to be ready, even if you have prior art. Unfortunately, the troll doesn't want you to go after it with prior art, but they're going to fight as well. Which is prior art's the scariest thing, but they're gonna crank up their legal funds and go after you even harder. And so even though we had HarperCollins and Simon & Schuster and all the biggest publishing companies out there, we had prior art. They had prior art, right? I mean, it's the story is not a happy ending, right? I mean, finally there was a settlement, but maybe in hindsight we should have just said, here's $50,000 and go away, or whatever we could have settled for. So,
Jeff, what's your story?
Oh, there's plenty of stories. The world of patent trolls is it's nuts. These mythical creatures are alive and well here in the U.S. and I think they honestly believe they're doing a service to mankind, and that they go to sleep every night thinking, yeah, I'm doing a good thing here. Sitting on my side of the fence, taking a more commercial view, not an attorney, but a business guy that needs to look and assess risks. When we've been sued on several occasions, and where just something is slapped down in front of us, we're defendants of some in this room against these patent trolls out of nowhere. And so we have to then take a calculated analysis view of the situation and determine, all right, what's the risk reward here? Do we want to go after a scorched earth policy and kind of a hell no, we're never going to settle? And depending on your view as a company, that's fine. And then you fight to the death. And so we've done that. Just recently, we completed a battle, if you will, with a patent troll that went after, well, probably 30 or 40 different companies, big high-tech companies, and some mid-size like ours in the hosting industry, UK2 Group and others. I'm not sure if your company was involved in this last one, yeah. And so it's e-contact technology. And so we went through this battle and back and forth, and as we kind of assessed the risk, we determined that we're going to fight. And in this scenario, we chose not to settle. And we put together our strategy, met with our attorneys, and I can go through a whole process later on of kind of what we do in real world. But in this situation, we were able to prolong this long enough that the case was resolved and it was dismissed. And it was a victory for mankind. And it felt good. Now, that's not always the outcome. You know, Christian and I know others that we've dealt with a year or two ago where, you know, we had to settle. And the risk was just too great. The costs were too expensive. And we worked out a settlement. I hate that.
When you won that case in e-contact, did you get your attorney's fees paid?
No, not even close. And that's what my British counterparts back here, they can't figure this out. They're saying, well, why wouldn't the bad guys then pay your legal fees? It's not the way it is. I know there's legislation being proposed that will change that, and that would be fantastic. But no, we still had to pay our legal fees.
Julie, tell us about fighting to the death. What's the...
Yeah, so I mean, I think you got to think a little bit about the framework of the legal system here and the litigation system surrounding patent trolls. So first, I'm going to take a quick step back. I think the root of the problem, frankly, are a lot of crappy software patents. We've got really crappy software patents floating around, you know, hundreds of thousands of them, and if they end up in the wrong hands, then they become weapons. So I think we see many symptoms of this, but there are two distinct ones that kind of make it in the news. And the first are the big patent battles, the Apple versus Samsung cases, the smartphone wars. And that's kind of interesting. It's interesting to people who follow business. It's interesting to some people who follow tech, but really it's not that interesting to the rest of the world, right? It's not really a compelling story. And then, so that's one symptom. Then the second symptom is this symptom where the patent trolls prey on these smaller companies. And that's kind of, I think, what we're talking about here. And it's that they're able to use these patents, these vague, overbroad patents, as a weapon. And so that was happening, you know, it's been happening for some time, but in the past couple of years, it's really ratcheted up. They were going after these small, mid-sized companies. A lot of Jim Besson's data is about that. But in the past, let's say, 12 to 18 months, particularly last year, the patent trolls have started targeting really small players, individuals, end users, tiny companies. And these folks would get a letter in the mail and say, you owe us all this money because you're infringing our patent. And that just, you know, blew the issue wide open. And politically, it became a really hot issue. And so I think that's kind of the framework that we're looking at. But what those trolls are able to take advantage of is not just the patents, but the way the litigation system works. Patent litigation is notoriously one of the most expensive types of litigation. You are looking at years in court, you know, on average $2 to $5 million per side in legal fees, though not for the patent trolls because they don't really have much, you know, they own a patent. They don't have anything else. It's really easy for them to litigate. That's actually their business model, should they get that far. So you get one of these letters in the mail, you've got a company, and you face this choice. Go to court, spend millions of dollars, spend years in court battling it, which is stressful and drains resources that aren't just financial, you know, engineer time. When those folks are stuck in deposition, they're stuck testifying. We don't want to waste days with our engineers in court. We want them to be, you know, in the office or in their bed with their laptop, whatever the engineers usually are doing, I don't know. But, you know, the point is that when you face this choice, it makes sense to settle financially. And we want people to fight the patent trolls back, of course, because you really are just kind of adding fuel to the fire when you settle, but you can totally understand why a company would make that choice. So that's kind of the overview of the problem we're facing. And I'm happy to talk about it, more of how that shakes out, but I think we'll see how we move forward.
So, John, tell us just kind of what your thoughts are on these cases.
Right. Yeah. I mean, I think the points that have been made are very good. That I think part of the real problem here in the space you're working in is that we do have these software business method patents that are often drafted in a way which makes it very difficult to determine their scope. Often it's difficult, or has been at least difficult, for the USPTO to assess their quality and value and to kick out patents that should be viewed as invalid over what's called the prior art. So that's one problem. Of course, that's a more forward-looking problem in that those patents are there. You do have mechanisms to try to challenge them, either defensively. If you are asserted, you can fight back against the alleged scope of those rights, or you could potentially try to trigger what's called a reexamination or a post-grant review proceeding before the USPTO, which can be cheaper and could stay the litigation while that's pending, but often is only available in limited circumstances. And then a huge problem, as multiple speakers have pointed out, is that the cost of patent litigation tends to be front-loaded, and that most of it tends to occur during what's called the discovery process, when both sides are just gathering information. Even if the overall fees are only about $1 million, and you can run up, I think on average, it's quite usual to have $1 million in attorney's fees when $1 million to $2 million is in dispute. So you can imagine both sides are spending $1 million. Why are we only $2 million is at issue? It doesn't seem like a particularly efficient process. But even worse is that most of this is spent in discovery before you've had any sort of summary judgment or trial proceedings. You'll spend, say, $700,000 out of your $1 million, and that makes it very difficult. That's why I think people get very frustrated. They have to spend all this money up front before they can even get a chance at a judgment. So I think these are reasons why we do see, I guess we're going to move toward potential reforms, pushes both on the side of substantive patent law, can we try to improve the quality and the clarity of patent rights, but also litigation reform. Fee shifting has already been mentioned. To try to deal with these rights that are already out there, can we get a quicker way of adjudicating these without having to invest $1 million up front?
So some of you may have heard about the President's or the White House's recommendations on patent reform, and they included legislative recommendations as well as some executive actions. So I just want to go down the panel. If you had to pick one thing to fix that Congress could change, what would it be, Julie?
That's actually a really hard question for me because
That's a trick question.
yeah, I think that I'm really in favor of the president's proposals overall. I think they're great. There are about 5 different pieces of pending legislation on the Hill. I think overall, most of them are quite good, some better than others, but I don't think any one of these legislative proposals is a silver bullet. I really think that to get to the root of the problem, we need to think about what we patent, how we patent, and whether these things should be patentable at all, particularly software inventions, but there's no political appetite for that question. So right now, that's just not, a viable question. The courts might look at it. We're working hard to fight this fight in the courts too. So that's kind of a separate track. That said, I'll quickly say I think the 2 proposals I like the best, assuming they have real teeth, when the legislation comes out, they actually have teeth, are these ideas of fee shifting. At the end of the legislation, it's come up a bunch. The loser, the troll, would pay the fees, assuming the troll loses. And these ideas of end user immunity, something that Alan has been really influential on protecting. We've seen, so a lot of the problem is, just for a second, sorry, let me back up, that people use generally available technology, off-the-shelf technology. use some shopping cart technology on your website so people can buy something, but you don't invent the shopping cart technology. Or let's say you're a podcaster. The podcasters are facing a patent troll problem, and you didn't invent the podcasting technology. You just record something and put it out to the world, and all of a sudden a troll comes after you. But you don't know anything about the patent system. You don't know anything about the patents that are out there. I don't think that those people are the ones who should be targeted. Maybe the manufacturer or the original developer of the technology should fight that fight. But we have a real inequity here. So I think those are my two favorite reforms. But really, anything that makes the world a little bit harder for patent trolls and a little bit easier for those who want to fight them is good. Because right now, the playing field is totally tilted. It's easy to be a patent troll. It's relatively cheap to be a patent troll. And it's profitable to be a patent troll. So we need to make it harder for those people.
Russ?
Yeah, I agree. Fee shifting would help. If you're going to pick a fight, you should be prepared to pay the consequences if you lose. That's a big one. Also, you should be an operating company, right? You shouldn't just be able to set up hang out a shingle outside your door and start suing people, right? That if you're an operating company and you're in the line of business and you have patents that are in your line of business, and you're prepared to pay the consequences if you lose, hey, business is business. But if you're just going after, and you are an attorney or you have someone that's going to work on the come, and then you can rack up on the other side's multi-million dollars of fees, that's just not fair. And so that's hopefully these people, everyone here can get involved and talk to your congressman and help Alan and the I2 Coalition really help change things.
Yeah, I think we're 3 for 3 here. I think fee shifting is a big issue, and I agree with Russ. Just this notion of their sole purpose of existing is just to acquire patents and then sue some more is quite annoying. I do believe if we were able to shift the fees, it would put a big damper in their approach. In fact, I was reading a study, I think it was a congressman from Oregon, I'm not exactly sure, Alan, where I believe up to 80–90% of these patent cases are settled out of court. But once they go to court, anywhere from 10 to 25% of the time, the troll will win, meaning 75 to 90% of the time, guys on our side of the table will win. And we will then rack up a lot of legal fees. And if we can shift that to them, when we have the overwhelming odds are in our favor to win once it goes to court, I think that would make a big difference.
Professor?
All right, yeah. So, fee shifting is certainly intriguing, since a number of people talked about it. I'll just talk a little about something else that's mentioned, just as I believe Julie mentioned earlier, the idea of end-user immunity. Or some variant of this along the lines of fair use or capping of potential damages against end users or certain types of developers. I think we do have in copyright a fair use exception for infringement. It's problematic there. I think it should be more robust. Patent law is distinct in that there is no fair use exception and an experimental use exception that is essentially useless for general practical purposes. And so I do think trying to introduce that kind of exception, limitation on immunity or damages against certain players in patent rights might be one way of helping addressing these problems. I should say also, just an important thing for small companies in this area is to try to make sure you're heard, to tell your stories as Russ has done. This was an interesting story that I hadn't heard or really thought of before about how these indemnification agreements can create a real problem for a small company that's been dealing with a big business, which can result in a potential liability way out of proportion to their own revenues, or what you might have thought was their own sort of percentage aspect of the larger business they're dealing with. So that's an important thing for me to hear about, maybe me. I guess just it's nice for me to hear about it. I may
I'm
not
glad
be
to
that
help.
important,
You know what I'm saying?
but it's important for policymakers, more importantly, to hear. I might be a channel to maybe writing something that gets out to policymakers, but it's important for policymakers to know that. I think this pursuit, as Julie said, of smaller users and developers of technology has been a new development. I think it's something that Washington is starting to get educated on, but just hearing what the experiences are of people, how these contractual agreements are structured, I think is very important for people to try to figure out how to solve these problems. So I just want to thank everybody who's come here and want to encourage you, if you are in these situations, to make sure your voice is heard in some way as to what your experience is.
Can I jump in for a quick second
course.
to build on that? I think another really big problem with the patent trolls is there's an asymmetry of information problem, particularly because so much of this happens pre-complaint. Before the patent troll ever sues, so much happens just letters, negotiating settlements, et cetera. So there's actually no data on that for the most part because it's not public. Unless you file a complaint, it's not public. So a lot of the legislative proposals have to deal with that. And it's also something that we're working on at EFF that we plan to launch this summer. So I have to make a quick plug. I'm sorry, but I really think it's going to be awesome. And it's we're creating a database where individuals can submit their demand letters. We're going to have protection so people redact their personal information and stuff, but create. Shine a light on what's happening. Make this public. Imagine you are a really small business. Imagine you're, as many of you are, but imagine you're in a position where you can't even afford a lawyer, even a couple hours to look at a demand letter. We hear from these people all the time, and they get a letter, and lots of people will tell them to ignore the letter, and in many cases, that's good advice. But the truth is, you don't know if the patent troll is going to sue you or not. And you start Googling around, but these patent trolls know what they're doing. They're good at hiding themselves behind Google walls, if you will. Let me tell you really quickly about what I think is probably one of the most egregious ones. This is a patent troll who claims that it owns the technology for scanning documents to email. Period, full stop, that technology. They claim they own it. They started sending letters out, we think it's well into the thousands, demanding between, I think, $900 or $1,000 per employee if you use this technology. They haven't sued anyone that we know of, and they've created a series of shell companies, and the names of the shell companies are 3 letters, 3 random letters, different, obviously, 3 random letters. So when you go to Google it, it's really hard to get any information on what's going on. So you're a small company, you're a small real estate shop. I just heard from one of these. It's a couple, they have a small real estate office. They get this letter in the mail. They're like, well, what the hell do I do with this? I'm infringing a patent for scanning documents to email? That is the problem, the worst of the problem, I think. That's really the worst of it. So what we're trying to create, and what I'm really excited about, is this place where people can go and get information. They can make more informed decisions. They can calculate the risk better because they'll be able to go to this site and hopefully get some more information on who the particular troll is, maybe find out that this troll sent out thousands of letters but's never actually sued. And if that's the case, maybe you're just better off ignoring the letter.
Well, that's actually the topic that I wanted to cover next, kind of in our next few minutes. And then I'd like to leave a little time for Q&A if anyone has questions for this great panel. What do you do if you get a demand letter? What are you supposed to do? Professor, do you want to take that one? And I'm sure Julie's got ideas too.
Oh, well, yeah. I think Julie's already hit on it a bit. It does create a kind of tricky situation where, a number of speakers have suggested, in many cases, the best thing to do may be to ignore it. But it's also a risky course to take because that might just encourage the patent troll to come across to you more. I guess. As a law professor and someone who wants to get jobs for our students, I should say, you should always immediately consult a lawyer and get their advice. I think Julie is right. If you can find out something about the nature of the entity who's making the assertion against you, that can be helpful to give you a sense of the proper way to proceed. Is this someone who just sends out these letters promiscuously and is unlikely to follow up? Well, maybe then you should wait, at least force them to kind of follow up with you one or more times so you get a sense they might actually be serious. if they are an entity that's more selective and is known to be quite aggressive in pursuing someone in litigation, then it seems more likely you're going to have to consult a lawyer, in part because, as has been pointed out, assessing the scope and quality of these patent rights can be very difficult. Can even be difficult for lawyers, but can be almost impossible for someone who isn't schooled in the sort of weird way that patents are often written.
Can you go on the offensive? What can you do? Can you sue the patent troll if you get a letter?
Maybe. So this is kind of, I don't want to get too far into the legal weeds, particularly with the law professor sitting to my right. But depending on how the letter is written, you might be able to bring the patent owner into court and say, court, tell me that I don't infringe this. But in order to jump through that hurdle to get there, the letter actually needs to present essentially a real threat of litigation. And the patent trolls have gotten really smart at writing their letters to get, just under there. They use just these magic words, if you will, so that it can be kind of hard to do that. So the answer is maybe. But I think something to think about, and you bring up a good point, and I think probably for this audience in particular, I get the impression there are a lot of smaller companies here that do have some resources. They probably don't want to use them on patent litigation, but people who feel strongly about this, I think you can form joint defense groups. You can find people facing the same trolls. You can come up with some economies of cost that make it more effective. Now, I do a lot of advocacy in this space, so we'll take on one patent troll or one patent at a time. Obviously, that is a drop in a bucket. That said, if you do it effectively and make some noise about it and tell your stories, it's really, really powerful. People on the Hill are paying attention. The president is paying attention. It's in the news, it's making news, so now is the time to do those kinds of things. The impact of actions against patent trolls reverberates very loudly right now. And I think we talked a little bit about reform, and I hate to prognosticate like this, but it seems pretty clear that if not this Congress, maybe the next Congress, we're going to see something happen. There's a lot of momentum. We just want to make sure that that something is good, that it has teeth, that it actually does help fix the problem. Because, as many of you know, the sausage-making process in D.C. is a mess. So I would just encourage folks who do have some resources and care about the issue to think about ways to help put the issue forward.
I will just say I2C, the organization that is sponsoring this panel, is very active in the patent reform legislative effort. So just simply joining that organization is an affirmative act to do something about this problem.
Alan?
Go ahead.
Let me just give a quick view from the business side, not the legal side, because I don't want to deal with this at all. I want to sell shared hosting, cloud hosting, dedicated hosting, and the rest of this is just a waste of my time. Seriously, it is so annoying, and it is for Russ as well. So when, in the past couple of years, we've had one letter that we received. They wanted these license fees based on, live chat. And we all use chat systems, so we're all, being sued. The other one was based on web-based email, Horde, Squirrel Mail, when the autofill function in email. You get the idea, a huge scope. So when I receive these letters or an actual, lawsuit, first thing I do is I read it. I read it thoroughly, and I'm not an attorney, but I still want to understand from a business perspective, okay, what do I believe my risks are here? And then I get the real smart people together in a room, and we all read it, and then we all discuss it. And then I ask these real smart people to go do some research, understand who these trolls are, understand what other cases are. So I don't talk to any attorneys for a while. It's just, all right, let's see what's going on. And then I deliver bad news quickly, which is always the art of enchantment from Guy Kawasaki. You tell the CEOs, hey, we've been sued. Here's what's going on. Let's deal with this now and have some discussions. So once we go through all this risk assessment, then we start having discussions with our attorneys. and offer advice. I call David Sneed. Hey, David, what do you think? And if there's others, there's 7 or 8 of us on this as defendants, we've had conference calls where we get together and say, hey, let's band together, let's share some fees, let's fight and make some noise here. And then each individual company has to make the determination, I'm going to fight it or I'm going to settle based on their own commercial risks.
That's a good way to approach it.
Right. Can I add, just on going on the offensive, there is what's called the declaratory judgment action, where you can go to court against someone who's sent you an inaptly worded letter. You can, as I said, also, there are these administrative proceedings you can try to trigger, reexamination or, under some circumstances, post-grant review before the USPTO, where you can't challenge so much whether you're infringing, but you can challenge the validity of the patent under certain circumstances, whether, say, it was a non-obvious invention. And those can be cheaper than, you know, a full action in federal court. They're often seen as having drawbacks because many people feel, particularly if you trigger what's called an ex parte reexamination, where you aren't so involved that you're kind of leaving it up just to the patent holder to work out with the patent office again. And the patent office is in the business of granting patents, so you're going to get some patent come out of that, was often the concern there. There are what are called inter partes proceedings where you can stay involved, so it's more like a kind of mini litigation. But those, as I said before, are restricted in their availability. However, they have been being used more and more, and so it might be a kind of hopeful route you could try to pursue under certain circumstances that would be much cheaper than a district court action. But as was just pointed out, I think it's very important. These decisions of what you do, it's really an important strategic business decision involving assessment of cost and risk. It can be difficult, even when you go to a lawyer, when they try to assess it. Lawyers often are fairly conservative, and I remember when I was in private practice, we had attorneys at firms who would just be frustrated because they'd say, yeah, it seems like you talk to a lawyer and they're going to come back with 1 in 3 answers about what sort of the odds are of a case you know, being won by one side or the other, which is 20%, 50%, or 80%. And that's it. And that's not enough. I wanted a little more precision. I wanted, like, you know, I thought, if you think this is a frivolous case, why can't you just say 0%? And partly, it could depend. Different lawyers have different approaches. My firm may have been a little more conservative. But, you know, lawyers often don't want to say 100% or 0% because then they might worry if it does go the other way that you'll sue them for malpractice or something like that. So, but, you know, it can be frustrating. Even when you go to the lawyer, you may not get the clarity you think you need. So I think it is a good point, though, as I said, it can be very difficult to assess these cases by yourselves. Ultimately, you may have to make a kind of difficult business decision.
It's a really good point, too, the things you can do at the patent office. And those are usually good opportunities to involve the community. And I'd like to really quickly tell you guys a story about something that we're working on at EFF. So I told you there's a patent troll who's going after podcasters. A lot of those, it turns out, you know, podcasting is not the most lucrative business model. So a lot of these folks can't afford lawyers. So what EFF has done is we've partnered with a law firm, pro bono, and we're working with some law students at Harvard. And we put out, you know, a call on the internet, and we said, we need the costs to file this thing. It's going to be probably about $30,000, one of these inter partes reviews. They usually cost closer to $100,000, but we're a small entity, you know, by the terms of the law, so it's cheaper for us. We need to raise about $30,000, and we want your help in finding prior art. We need you people to show us that this patent was obvious, that people were podcasting before 1996 in some form or another. Our goal was to raise $30,000 in 2 weeks. In about a week, we had raised $70,000. It's like 73 right now, last I checked. And we've gotten tons of amazing prior art, things that we probably wouldn't have found otherwise if we went through, you know, typical lawyer channels, if you will. So what I'm trying to say, again, I don't want to sound like a broken record, but there really is a lot of interest in the community here. And if you ask for help, it comes in good ways. So, I mean, this is what EFF does, and we're really excited about this project with the podcasters. But I think, I don't know if what we're doing is scalable, but it is, you can replicate it. So that's out there, too.
A few good wins go a long way
Yeah,
too.
I think that's right.
So we have just, I think, about 5 minutes left. Is that right? So I'd like to open it up for questions if people have questions. It's a small enough room. Anyone? Back in the back.
Hi. So I'm interested in the panel's opinion on companies like RPX or patent litigation insurance as a small business owner, small software vendor.
I'm happy to take that. Rackspace is a member of RPX, and we've looked into insurance a number of times. And for a small business, it is not a good idea. It's just a waste of money, generally. RPX is their business model, and I won't get into the details too much, but it's effectively is you pay them a fee every year. They buy patents and take them off the market, if you will. So you get a license to those patents. That's really about all they do for you. And I think for a small business, it's not a good use of funds. Insurance, again, not good at all. They generally have so many exclusions that it's not worth the paper it's written on. Just my opinion.
Agreed?
Any question here?
Yeah, fee shifting sounds like a good start. There's a big difference between the award fees and the recovery fees, actual money in the bank from the patent troll to the prevailing defendant. I'm just wondering if the panel has any thoughts on how to make an award of fees actually come down to hurt the patent troll. These are essentially ephemeral companies. They're going to, if they get an award of fees against them, they're going to roll up ABC company and dissolve that and start up as XYZ company 6 months later.
Great question.
I've got a lot of thoughts on this one. So you hit on something really important. There are a lot of these proposals floating around DC right now, and depending on how they're implemented, like I think fee shifting is a good idea, but if it's not implemented well, then it's not really a good idea. So for fee shifting to work, I think you need to have a bond at the outset. The troll would have to put up a bond at the beginning, and if the troll wins, gets its money back. That's fine. But you hit on what's a very important point, and it's that trolls really benefit from this shell game that they operate in. So requiring to put up the money up front would be a big deterrent to crappy lawsuits.
Good question. Yes, sir.
Is there any possibility to use shaming as a kind of a discouraging technique?
No.
No?
Oh, no, there is a possibility.
Shaming?
We're trying.
Well, we shame them all the time.
They're shameless.
They're emboldened. They make so much money.
Well, I think I think some of the legislation would help, because right now what you see is there are a lot of companies that are, quote, legitimate companies, and then they kind of spin off a shell.
That's true.
And you don't know that that shell company is actually related to this company that has a pretty strong brand in the marketplace. So a lot of the legislative proposals would get at this. They're kind of called, we could talk about real party and interest reform, so that you would actually know, I don't want to actually say, Intellectual Ventures, for instance, is a big company who's behind a lot of these cases, but you wouldn't know it because the name of the company is something different, so that you'd really know. And it's not just the Intellectual Ventures, but a lot of mainstream companies that you might not realize are behind it. So it might not shame the straight-up professional trolls, and I think that's kind of what you're getting at, Alan. But there are a lot of these other-level trolls that it would discourage.
Or like the law firms who represent them.
They don't care.
Yeah, they don't care.
They don't care. Lawyers, they don't
Though
care.
it does, I do think that atmospherically it makes a difference. So I think for a long time, the really early patent trolls, I don't think they realized the negative effects. I think they just thought, oh great, this is a licensing business. I really don't think the early ones had bad intentions. It's just kind of spiraled out of control and gotten really bad. So the more light we can shine on this crappy business model, I think, the less young lawyers are going to want to do it. They're going to think it's an ethically bad choice, and that's good. That's the long game.
I will say, some law firms actually do care and want to be seen as firms that aren't involved in
He's right.
representing non-practicing entities or patent trolls. But there are others that maybe just plaintiffs' law firms generally that might just view this as another type of plaintiff's lawsuit. And I think Julie is right that some of them did view this. And some probably, still view it as something where, these are rights that have been issued. We're just looking to vindicate these rights in an underserved, what they view as an underserved legal market. And again, just to repeat my point, that's why I do think it is important that, you tell your stories, register them somehow with an organization like the Electric Frontier Foundation or somewhere else, so we know, have a better idea of what's going out there. One thing that often happens if you have a case and it settles is you may then be under a non-disclosure agreement, so you can't talk about that particular case. And it's one thing that makes this area very difficult to study and for policymakers to understand, because a lot of what goes on is just unseen and covered by confidentiality agreements. So when you aren't covered by that, it's just even more important to make sure you let people know what's going on.
One last comment. I had a CFO years ago, and I've used this phrase before. He told me, he says, Jeff, in deals, in sales, or whatever the opportunity you're facing with someone, it's either your kids or their kids that will win. And I've thought about that a lot in my life, because anytime we're dealing with a battle here, the patent trolls and their kids are going to win if we allow them to, if we just kind of not do anything and sit back and let them steamroll us. Or if we fight and we're advocates, then our kids are going to win. At the end of the day, we're going to be victorious and you know, take care of our own, if you will. And so it's a good life lesson that I've appreciated that applies to, I think, this battle that we're all facing. So we need to be advocates and help each other.
Yeah, let's beat their kids.
I've got to say,
Well, I didn't say that, Alan.
Thank you very much, everyone. Thank you, panel.
That's good.